Alright folks, I talked to you quite a bit about politics to no avail. It doesn't seem to be something you're interested in, but know that my intentions are good and to help all comrades of my land. So this video is pertaining to the law and any of my comrades who I know have been persecuted by a corrupt judicial system. What you must understand when I say corrupt, all of you that have been in trouble and not been able to afford a lawyer were appointed one by the state. Now what you must realize about that is a state lawyer and a state prosecutor are all branches of the same tree. They all work for the same people, and it is in their best interest to strike a plea bargain before they would have to go through the expense, which is mandatory if you choose to go to trial. If they want to go through the expense of getting 12 jurors and paying for 12 jurors throughout the trial, and they don't want that expense. So, in cases of felony, within 10 days, the state has to grant you a preliminary hearing, and in that preliminary hearing, they must assess whether they have enough evidence to move forward with trial. Now, within 10 days maybe of your arrest, the prosecution must present you or your state lawyer or your lawyer that you paid for. They must present to them something that is called discovery. Now discovery is, you're entitled to your discovery, so you may prepare for trial. Now in that discovery is all the evidence that the state has supposedly piled against you, and you must be presented with it to prepare for trial. So here is an example of discovery in my case, in the case that I face. If I can find my paperwork, folks, give me just a second. Okay, this is a discovery in one of my cases. And Pete Blair taught me early on if I didn't have the money to buy a lawyer, it would be better off to invoke your Sixth Amendment right and try to defend yourself until you gather the money to pay for a lawyer. Okay, right back to the discovery. The discovery has to be turned over to you within approximately 10 days. Okay, now in that discovery, as I said again, is all the evidence that the state has compiled against you. Alright, now the first thing in that discovery will be definitions, the state's definition of the charges that they have put on you. Okay, in my case, which I did win, and it's important to note that I'm not a lawyer, I'm not even a jailhouse lawyer, but every American is entitled and so should learn their constitutional rights. Okay, in this discovery, I've been charged with 5 charges here, 2 of the same. Okay, the definition, they give you the definition of the charges. Okay, I was charged with obstructing. The definition of obstructing: any person who by threats, menaces, acts, or otherwise, forcibly or illegally, hinders or obstructs or attempts to hinder or obstruct a law enforcement officer, probation officer, or parole officer acting in his or her capacity in violation of West Virginia Penal Code. Okay, now that's obstruction. Alright, now I have been charged with assault. Not just assault, but assault on a police officer. Okay, Now, this is assault on a police officer, but it's about the assault in general. Okay. Did unlawfully attempt to commit a violent injury to the person of the police officer, probation officer, conservation officer, so forth, so on, etc. Right here at the bottom it says, reasonable apprehension immediately receiving violent injury. Okay, employer, state correctional employer, mass transportation system, in reasonable apprehension of immediately receiving a violent injury. Okay, it says mass transportation police officer that you reasonably immediately receiving. To be clear, you threatened them with a violent injury by mouth. Okay, you must understand there's a difference between assault and battery. Okay, an assault on a police officer, on a regular person, by law, must mean that you threaten them with violence. Now you can say this, you can say that, but do not threaten them with violence, because that is where the charge comes in. Okay, now when you're first arrested, a police officer must write up his report to explain his reason for arresting. Okay, now they must do this as soon as they arrest you. Now come time for trial, you know, what I never understood is how somebody could enforce the law and know nothing about it. Okay, now the next thing they'll have in your discovery is a statement. Now let me explain to you the importance of a statement. A statement is not worth the paper it's written on unless the person that the statement was took from can hold up in court, can face cross-examination, and is mentally sufficient to stand up in trial and stand up on and get on the stand. So a statement, if the witness is not credible or mentally I'm not going to say ignorant, but let's just say they're not mentally fit to stand trial. So, in short, don't be scared of the statement unless you believe that the person that gave that statement is credible and could hold up in court. Now, what you must understand is, if all they've got is statements and see, the report that the police officer wrote up, in time, he will forget a lot of times what he had wrote up. So if you're in possession of this, and in trial he testifies to anything in this statement, anything different, if he testifies to anything indifferent with this statement, what does that prove, folks? That proves that he's not telling the truth. He either wasn't telling the truth when he wrote the statement up, or he wasn't telling the truth in the courtroom. If he wasn't telling the truth in the courtroom, if his testimony contradicts this statement, that proves his own uncredibility. He's not credible as a witness, whether he be a police officer or not, if he testifies to something completely different than he put in the report. Okay, now a good lawyer, the discovery I just presented you with, a good lawyer will look through that discovery. If there is nothing in that discovery to convict a man beyond a reasonable doubt, understand, beyond a reasonable doubt, it is hard to prove anybody guilty, even if you are guilty, beyond a reasonable doubt, unless you're